Hey everybody, welcome back. It's time to get started. Tonight we're going to cover the new 1-2 punch lawsuit package that I put together to help you people that lost in foreclosure court. Yep, this new package you'll be able to use if you lost in foreclosure court up to 15 years ago. And don't ask me how many wins we have, okay? Because this is new and our concepts absolutely new that we're doing. So I don't see too many other people doing what we're doing here anyway. So if you got to ask how many wins, I don't think that you need to use package. I need people who are willing to step up and get the wins. At the end of the day, it's not whether the package wins, it's whether the person using the package can make it through the fraud that the attorneys stick in your face, the bar members, because these bar members include the judge, the attorneys, the clerk, pretty much anybody involved in the system on the other side that understanding where you're at is involved. And the fraud is what blocks people from getting through to where they need to be, not the package not being correct. Because my documents are fire. We're also going to talk about the rules and which set of rules they're making you follow. So it's time for practice to start. But before we get started, you guys make sure that you click on those ads that pop up so I can get paid. Let's just get right down to the brass tacks. Did you lose your house to foreclosure? Maybe you're a property investor that lost several properties to unlawful foreclosure. If you could go back and challenge the foreclosure, would you have the courage to do that? How much would you be willing to invest in a lawsuit package that will help you challenge the unlawful foreclosure that happened already? Let me introduce to you the 1-2 punch lawsuit package. This new package challenges the court's lack of jurisdiction at the gate. And just like you understand, if you've been in my program at all, we want to keep them at the gate. The way this works, the jurisdiction, now this package is called the 1-2 punch, and it's called the 1-2 punch because it contains, well, I'm going to show you a little bit later what's all in it. It actually has more than 2 documents in it, but I'm hoping you don't need to use but these 2. So the jurisdictional challenge with an affidavit is the same. We changed it into a jurisdiction challenge with an affidavit. Now, there is a jurisdictional challenge with an affidavit. That is a package that supports the lawsuit. Okay, this jurisdiction challenge with an affidavit lawsuit package has its own lawsuit inside of it. And basically what you're going to do is use the jurisdiction challenge with an affidavit because they can't answer by counter affidavit. So you already know that they're not going to be able to respond on the merits. So you should already be getting your stuff together, what you're going to do next. The jurisdiction challenge with an affidavit will be used to reopen the foreclosure judgment against your property. Now, remember, if you're in non-judicial, then you're going to have to reopen this case in the eviction court. Open that up, the new lawsuit package where you're suing the judge for unrelated stuff, the Administrative Procedures Act, the Foreign Agent Registration Act violation, and the Fair Debt Collection Act practice. Okay, that lawsuit you can file against the judge before the judge rules in the case. Yeah. See, y'all with me? So you're going after the judge to prove the judge is not legal because the Administrative Procedures Act of 1946 is a federal law, and the judge is in violation of that law because the court rules are not in line with the Constitution. The Foreign Agent Registration Act, the judge is supposed to register with the National Attorney General and all of that stuff, and they are not. So here's the beauty of this. You challenge the judge, you file your challenging the court, and then you sue the judge for unrelated stuff that don't have shit to do with what the problem is. And now you challenge the judge for not being legal. And if the judge is not legal and you get this shit on the record that the judge is violation of 3 federal laws, that's going to be a problem for the judge. And now all the judge's stuff is going to have to be called into question. This is pretty powerful. And then you recuse the judge after you get done filing your stuff. Or maybe you recuse him before you file your lawsuit. I don't know. You're going to object to the judge's ruling. You are going to file your motion for reconsideration. You're going to challenge the court's jurisdiction. And then you're going to file your notice of claim against the judge. And then you're going to file it to recuse the judge. And then you're going to file the lawsuit against the judge for violation of this other stuff. And now the judge is going to have to step down. They don't have a judge. You're suing the judge for unrelated stuff. Think about it. Violation of the Administrative Procedures Act, the judge in violation for an Agent Act of 1936. Now, if you try to look up the Administrative Procedures Act of 1946, you need to make sure you put 1946 on there, or you're going to pull up Cornell Law Library, watered down bunch of BS. Game plan for using this package is to block the judge from ruling on your jurisdictional challenge. This strategy will cause the new judge to reevaluate the situation, as the judge will be aware that he or she could end up in the same position. So basically, you file your jurisdiction challenge with an affidavit, and then you just go ahead and file this lawsuit against the judge. And you could add the attorneys in here too. And let me explain to you how much power you have, okay? People have no idea how much power they have. You got my lawsuit, you can file it against the corporation, you can file it against the attorney, you can file it against the court's corporate charter, you can claim the corporate charter as in your claim, so as damages. So that's part of what you're claiming for, your $5.5 million, the corporate charter, the attorney's bar license. Hell, my sister sued the attorney that was coming after her for his house, and we served them. Well, she served them, okay, because she did all this. Yeah, she's a badass. She served them at their house, and she added his wife to the service. So she's suing them not only for his bar card, their law firm's corporate charter. She's also suing the attorney. She was until they terminate her case. She's suing the attorney for their house. And when I say they, I'm talking about him and his wife. Yep. And we served them and put her name on there. So, oh, they were really freaking mad. He was really mad. I read his response, and whoo, he was really angry that we served him and his colleagues at his colleague's house. And it's interesting, they went through 12 or 13 attorneys. And the last attorney that signed entry of appearance to let the last attorney that we defaulted go back through again, that's who we sued. It turns out that last attorney was actually one of the members of the law firm, and he was also an investor. And he went back to, and my sister did all of this. I'm like, what? She's researched his ass. So he went back to college and got his degree to be a bar member or whatever. And I guess he figured he'd just kick our ass, since the other 11 or attorneys or 12 attorneys, I didn't know if it was 12 or 13, couldn't get the job done. And so when he stepped in, we jammed his ass up too. And then we sent service to his house to include his wife, so she had to sign. Yeah. Sometimes I should be paying you guys for having all this fun. I'm just saying. Yo, she's crazier than me. So Alex, dude, you're right. I ain't even gonna lie, okay? I asked her one day, I said, sweetie, do you know how to tell when when an attorney is lying? And usually you say, their mouth's moving, Yeah. I said, do you know how to tell when an attorney is lying? She looked me right in the eye in like 2 seconds. She says, he's breathing. I was like, damn. That's not what I was going to say, but I think that trumps my shit, okay? She like, what? I said, I ain't messing with you. Remind me not to mess with you, okay? She says he's breathing. Okay, I think that trumps your mouse moving. Yeah. Thank you, MX Capital. I love this. Yeah. I created a master key, and it's easy to use. You just have to keep it simple and don't put none of their shit in it. Because when you add their shit in it and you argue about their shit, then you're screwed. You're done. Because their system is structured for arguing. And when the arguing's done, the judge gets to help them. Come on. If you do this right and you jam up the first judge, The new judge coming in is looking down and smelling that pile of shit, and they're like, I don't know who that legal team is, but that legal team ain't screwing around. That's all I can tell you. So you don't need to get in contact with me, Alex. You just need to go to the website and get what you need. It works better for me after people and make their investment and do the homework, make the investment, review the documents, and then if you have questions, you can email me or message me in the group or send me a message on Messenger with your question. That works out better because now our time is spent toward helping you with the problem. Most people want to call me and talk about all of that stuff, and I didn't want to talk about that stuff. And I have some people that get pissed off at me when I cut them off. But I'm like, okay, guys, you need to understand, I got the most calls I got in one day was 32. Usually the average between 8 and 12, 14, I don't know. But I don't have time to listen to a bunch of stuff that you're not going to use in my program. Now, that's what attorneys do. They listen to all that shit, and they know that you're not going to use any of that shit because they're going to screw you over. So, I'm just saying, for me, my time is valuable. A jurisdiction challenge with an affidavit. Let me figure out how to do a screen share. Okay, so this is the file. This is the jurisdiction challenge with an affidavit lawsuit package. It's different than the jurisdictional challenge with an affidavit because this has a lawsuit package in it. So basically what you're getting right here, the jurisdiction, the challenger jurisdiction. I'm just going to click on it and open it up so that you guys can take a look at it. Maybe. Yeah. Well, that's the jurisdictional challenge. This is the same thing as what you guys already have. I just named it something different because this package has a lawsuit in it. So this is the jurisdictional challenge with an affidavit. So this is the one that you guys all have. So it's the same thing, but the package is different with the lawsuit. And with that, you got your inventory notice of default, your motion for hearing on the jurisdictional challenge. You have here inventory motion for summary judgment, and you can and you can figure out when to use these. If you don't know, then you need to figure that out on your own. Okay. The inventory motion to moot, you would file at the same time you file your challenge to jurisdiction. And then this is your response. I put together inventory response because I had one or two attorneys try to file a response. It was told bullshit, but I put together a response anyway. And the notice of removal from state court. This is the document that we use to remove the eviction process from eviction court over to federal court. So if you file your title dispute in federal court, you can use this document to remove the eviction process from eviction court over to federal court because eviction court can only make a determination on immediate possession. They cannot make a determination on the title dispute, and your title dispute is filed in the higher court. When the title dispute is settled, then the higher court can make a determination on the possession, and we're sure it's going to be you. So, so that's how you roll on that. Now, this is what I've done. Instead of trying to redo all the documents, I just added this zip file to the other zip file. So, and then change the name. So this is the $2 million Administrative Procedures Act lawsuit, the new one that we had for $75 for a long time. And if you click on it here, you'll see you get 4 documents in that package. So you'll get the actual lawsuit. And I'm going to just click on it. I'll show you the front page. We're not going to go through the whole thing. We're just going to show you the front page so you can see that we're bringing fire to the table. I like that fire thing. Sorry, I get a little carried away with the fire. Okay, and I got it in 2 windows. I need to get it done. I was like, what the hell's going on here? Got it in 2 windows. I have a window on each side. So this is the lawsuit package. Now, we've been filing this in state court and doing real good with it. And this is what we did with my sister. We kept hers in state court and we worked out the program that we use for state court. And this, what I've put together here is just a short version. I'd like to get it down to as less documents as possible, but it's nice to have what you need to punch them so you don't have to come back and give me more money like you do attorneys. I'm trying to have everything in the package you need to go kick some ass. And so you can see this is pretty powerful. This is pretty powerful. And you can go to some of my YouTube videos where I talk about the Administrative Procedures Act of 1946, Foreign Agent Registration Act. And and this claim is also against the Bar Association and the defendant's bar card. Now, you can put this claim against their corporate charter for the court or the attorney's corporate charter or their house. Yeah. So we don't have a bunch of limitations in my program. And then the inventory notice of default. And then this is the motion to recuse the judge in case you haven't done that yet. So the biggest trick here is to challenge the jurisdiction, recuse the judge, and then attack the judge so the judge can't come back into the picture. And then the new judge has got to come into the picture. And the new judge knows if the new judge shits on you, you can do the same thing to the new judge. And in most cases, they ain't trying to have it because you've got enough on the record there. You build. See, in my program, we're not going into court asking the judge to rule on shit and asking them for nothing. We ain't asking them for nothing. And when you go into court, you ain't asking them for nothing. You're putting yourself in a different situation than you are when you go into court asking them for a bunch of stuff. We ain't asking them for nothing. We about to take some shit. So that's how we got this set up. And the reason that I don't need to hear all of the stuff that everybody's doing is because we're not talking about none of that shit. We're not talking about none of that. We want to talk about the shit they're doing wrong. That's what we want to talk about. I don't send anybody in the court to argue what they said they did or didn't do, because that's not going to help anybody. So that's what that package looks like. So you guys can see there's four documents in the lawsuit package, and 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 documents in the other package. So I didn't know what 4 and 9 adds up to, because I can only add up big bills. Okay, sorry. So I'm going to show you guys what that product page looks like. View. And you're going to see what we're asking for this puppy. So what would you give for lawsuit packages? You can go back in and challenge your jurisdiction up to 15 years later. Bam! On sale, $350. And 14, 15 documents. Yeah. This is the bomb. And my website is so pretty. So I'm going to the 1-2 punch. You file that jurisdictional challenge and follow up with the lawsuit punch for some unrelated stuff. How sweet is that? And now you don't have to argue all that banking crap, none of that. Now, all you got to argue is what's on the court record. Yep. In the end, you're going to use the court record to jam their ass up with. And they're not even going to figure out that's what you're doing until it's too late. By the time they figure out, there's nothing they can do, because they've already dismissed your stuff and did all these stuff, and they don't have an injured party. They don't have an injured party. And the foreclosure statute is not a valid law. It's in violation of the Constitution, of the state constitution, because it does not have the necessary elements to be considered a valid law. The elements are, each state constitution mandates that a law, for something to be a law, it has to have an enacting clause, which tells everybody from what authority the law came from, who's subject to follow, and it has to have a title, and it has to have a body. And statutes and codes have none of those. Could it be so simple? And I tell people this all the time, and I don't think I've had one person call me up and say, hey, I used that, I challenged them, and they went and sat the hell down. Everybody's so worried about how many wins did you get and how many and all this other stupid shit. Okay, so, and of course, I'm thinking, well, if you're not going to use something new, what you're doing must be working pretty well, right? I mean, I like to keep it simple. If people have all these questions and want to know how many wins and all this stuff, and what you're doing must be working, because from what I'm seeing, what people are doing is not working. And if there's something else that makes sense, then I ain't worried about how many other people use it, because them other people might be sissies. They might be scaredy pantses and sitting on their butt, or they might be the kind of people that are so worried about having everything perfect that they never get around to filing shit. Okay, I don't follow none of that.